as real property lawyers, and particularly as, lawyers acting for anybody involved in real estate, whether that's lenders, owners, or even contractors, and most of us seem to have a whole breadth of type of client, gets concerned when it comes to construction liens, and they're getting registered, and how construction liens bump up against mortgage advances. Stephen Pearlstein has studied this area. He loves to talk about mortgage advances and construction lien claims. He's lectured widely, and I'm going to call on him now to speak on the topic.
Thank you, Sid. Good afternoon. I hope everyone had a good lunch and you're ready to get back to work. As you just heard, I'm been asked to talk about mortgage advances and construction lien issues, and I actually have to apologize to you for the scheduling of this topic, because I'm sure a lot of you would agree that when dealing with the Construction Lien Act, a lot of you are sick to your stomach to start with, so to add a full stomach and to have to deal with it could cause some problems, but I'm going to press ahead anyway. Now, as you know, this is a big topic, and of course I can't cover all of it, so I've attempted to pick 6 topics, and I'm going to try to cover those in the time allotted. The 6 topics, and this is all in my paper, and if I don't cover some of this, you'll be able to get it out of the paper. The 6 topics are advancing in the face of a lien, the holdback provisions, discharging a certificate of action without court order, posting security, the trust provisions, and the home buyer exception. Now, one thing I want you to note when we go through this is you'll see that a number of these issues come up even though there's no lien registered on title. So a lot of people think, oh, I don't have to worry about the Construction Lien Act till I see a lien registered, and that's not the case, and I'll try to point those out. The first topic is advancing in the face of a lien. And I'm not sure why they keep calling this topic that, because it's actually very settled law now that, in effect, you should never advance a mortgage if there's a construction lien registered on title. There's actual case where a lawyer was held negligent for doing so, and there's the Bomers case, which goes into the effects. But let me just go over this with you. The key point here to know, and this is one thing to take away with you today, is that although we're all raised on this concept in registry and land titles that there's priority of registration. If your document is registered first, unless you had actual notice, you have priority. The Construction Lien Act changes that. Section 78 sub 1 says liens arising out of an improvement have priority over parties taking an interest in the land, deeds, and mortgages, unless you can find an exception in one of the subsections to 78 that give you priority. So a lot of people take this false comfort that their mortgage is registered first, there's no lien there, and remember, a lien arises on the day they put the first shovel in the ground. They only have to perfect the lien by registering a claim for lien within 45 days of substantial performance or these other time periods. So the lien, which arose, even though there's nothing registered on title yet, has priority, even though it's not registered and even though you may have registered first. It's an important concept to keep in mind when dealing with construction lien issues. Now, the other thing you should notice is that it says liens arising from an improvement have priority. So you may be able to deal with a lien on one of the contracts, and an improvement is defined in sort of layman's terms as the whole project. If they're building a new building, then the improvement is the whole building. If they're putting an addition on, then the improvement is the addition. It's the whole project being constructed at that point. So even if you can otherwise deal with a lien claimant on one of the contracts, the foundation contract or the lumber, the plumber, and deal with his or her lien, what it says is unless you can find priority under one of the other subsections of 78, all liens arising out of that improvement have priority. And you will see that the the only real way to have priority for an advance is if at the time of the advance there was not a registered lien. You can go through the different variations, but if at the time you advance there's a registered lien, you can't come under any of the subsections that give you priority. So that means you lose the priority for that advance, and you lose it for all time. There is no other way to get it back. And the Bomers case, which is in the paper, confirms this. And you not only lose it for all time to that lien claimant, but you lose it for all time to all liens arising out of that improvement. So you could settle with that guy and pay him out in full and do everything else, and 2 months later, there's a real major default, and hundreds of thousands of dollars of liens go on title, and your advance will be behind all of those liens as well, and there's no way to get it back. So this is why you have to be very careful, and in effect, there's no way you should ever advance a mortgage with a lien registered on title. You have to deal with it. It doesn't mean that there's not ways to deal with them, and there are 3 methods to clear title. I just want to mention, under the old Mortgage Lien Act, there used to be, that was prior to 83, there was this concept that if you held back twice the amount of the lien, somehow you were protected. Well, whether that worked before or not, just assure yourself it does not work now. There is no amount you could ever hold back unless you could independently determine the entire price of the improvement entirely, maybe, and then you could pay off everybody in full. But other than that amount, there is no amount that you could hold back to protect yourself, because even if there's a $100 or a $1,000 lien, you could potentially lose priority to millions of dollars of work. So if you're faced with a lien, there's really essentially 3 ways to clear title, and they're listed there. The first way is under Section 41, you can register a release in the prescribed form. And that's really, you negotiate, either you, the borrower, the contractor, somebody negotiates, and they either pay out all of the money that's owed to the lien claimant, or you negotiate some amount that they'll take. They show up with the release. And we're going to deal with whether the certificate of action causes a problem or not. Now, there's a case that I recite in the paper, Sousa Contractor, that it's definitive that you have to actually register the release before you advance the funds. So I think it's pretty clear that you have to do some kind of either escrow or show up at the registry office or at somebody's office to do an electronic registration where you hand the check. It's clear it's not released or advanced until they register the actual release. Even if it's prepared, signed, and delivered, but it's not registered yet, you're still advancing with a lien on title. The second way, which up till about 2 minutes ago I thought was never really used that much, is under Section 43, believe it or not, you can actually postpone a lien. It's not used very much because most parties want the lien issue dealt with and not have to face it later on. But one of the parties in this room came up to me just before I was speaking and said they're doing a mortgage advance, there's a friendly lien on title, and they want to cooperate. So maybe that's one suggestion. And the third way, which you've also probably seen and dealt with, is getting an order under Section 44(1) vacating the lien and or the certificate of action. You get that by paying money or security, a letter of credit, into court. Now, once again, in effect, you can't use the mortgage monies to secure the letter of credit that's going into court or to put into court, because you can't get the order until you put the money in. If you put the money in first, it means you've completed the advance. And when you complete the advance, the lien's not vacated, so now you've lost your priority for all time. So you have to have the borrower or the owner somehow must come up with a daylight loan or some interim financing or something which is not secured by your mortgage on that piece of real estate. Although he can do that with the assurance that that day, later that day, once the order is issued and entered and then registered, you could do an advance and have an irrevocable direction to pay back that loan. Usually it takes to the next day. But just be careful if people say, just cooperate, you'll give us the check, and then we'll put it into court and we'll run back over and register. You've really not done your job. Okay, so that's dealing with the ways to deal with a lien on title. The next topic I want to talk about is the holdback provisions. Now, the first thing that's important to know is there is no concept of a mortgagee's holdback. So you often see in a loan commitment that says something like the lender will hold back monies to comply with the Construction Lien Act. It doesn't make any sense. There is no obligation under the Lien Act for the mortgagee to hold back something. The obligations for holdback under the Lien Act are for an owner to hold back monies when they're paying their contractor, and for contractors to hold back money for sub-trades and so on down the line. Now, the concern of the mortgagee usually, and in fact I think every time, is with the owner's holdback. Because under Section 78, sub 2 and sub 5, the mortgagee will lose its priority in the land to any deficiency in the holdback required by the owner. And that's the consequence of the holdback to a mortgagee when you're advancing. Now, the other thing I see that concerns me in mortgage commitments and also in lawyers' advance statements or lenders' advance statements is, you know, they're doing $1 million loan. They calculate the holdback, the lien holdback of the owner should be $100,000. So they're willing to advance $900,000. And the statement of advance comes out and looks something like loan amount $1 million, construction lien holdback $100,000, net advance $900,000. And they think the lender's only advanced $900,000 and they're charging interest on $900,000. The problem with that is it may be that that document gets produced either by the owner in lien litigation or through a demand on you under the Act, and then you'll be deemed to have obligated yourself to create the owner's holdback under the Lien Act, and then the lender will be forced to produce that $100,000. So you want to be very careful that as a mortgagee, you call that thing unadvanced funds. I usually try to say unadvanced monies equal to the owner's holdback. And that's the way really it should be referenced. Because what you're trying to do is you're trying to maintain or hold back as unadvanced monies sufficient dollars to protect the priority of the mortgage under the holdback provisions of the Act. Now, this is an example of something that applies whether or not there's a lien on title and whether or not you actually think that you're doing a construction loan, because these provisions apply to what's called a subsequent mortgage. Subsequent mortgage is one that's registered after the first lien arose, and that's whether or not you knew that there was any work on the property. So, unbeknownst to the lender, the owner has contracted to do some work, and you're advancing a mortgage. The mortgage gets registered, the work has already commenced, they've come to do some drawings or prep the site, so the lien has arisen, you're a subsequent mortgage, and you will lose your priority to the deficiency in the owner's holdback. You don't have to be a building mortgage, that's one that's taken with the intention of financing construction to have to pay attention to the holdback. Now, as the lender, as lawyer, you're not expected to go out to the property and see if there's construction, but a lender should have done that site. Or you may find out indirectly. You may, from your building clearance letter, be told that there's an outstanding building permit to do some renovations and it hasn't been signed off yet. And that would clue you in that there may be construction that hasn't had liens expired yet and there's still holdback requirements. So you have to think to yourself, okay, I need to decide whether there should be a holdback. Now, how much should you hold back? 5 minutes? Whoa, I've only dealt with 2. How much to hold back? 10% of the actual work. It's not related at all to the amount you're advancing It's not related at all to how much the loan is. It's how much work, material, and services have been supplied under a contract. I'm just going to then discharging a certificate of action without court order. This is a topic near and dear to my heart because I was the first one to raise this in 1997 at the Annual Institute. You don't, even if there's a certificate of action on title, if you get the cooperation of the lien claimants, you don't have to get a court order to take off the certificates of action. If everybody that has a registered claim for lien and or a certificate of action signs the release, Section 41, sub 1 says a preserved or perfected lien may be discharged by registration of a release in the prescribed form. That's statutory authority. A perfected lien is one that's perfected by registering a certificate of action. So you don't have to. And in fact, there's a registrar's bulletin 96002, which is referred to in the material, which says the Land Titles Office will actually rule the certificate of action off. And I'm going to skip posting security trust provisions. I think it's important for you to be aware of this. This is another example of where you have to deal with the Construction Lien Act, even though there's nothing registered on title. The Act, Section 7-8, imposes a trust on monies paid to an owner in the course or intended for construction of an improvement, and this includes expressly under the section monies used to pay the purchase price or to refinance an existing encumbrance. And there's a case referred to, the G.C. McDonald case, where a mortgagee was advancing monies for construction, and it decided to use the rest of the money to pay off a mortgage it had on a second property that had nothing to do with this one. And the court held the lender had actual knowledge or should have known that that was a breach of the trust provisions, even though there were no liens registered at that time, and made the mortgagee pay that money back into the credit of the lien actions. So if you get, for example, you're told there's a house, you're going to do a mortgage for $250,000, $150,000 to pay off the existing mortgage, and $100,000 to renovate or put an addition on. You pay the $150,000 to discharge the existing mortgage. The borrower client gives you a direction to pay $50,000 of the remaining $100,000 to his brother or to somebody else. And you know from the commitment it's supposed to be for construction, you may be assisting in a breach of the trust provisions, even though there's no lien registered at the time, and you may have to pay that back in. In any event, I'm sorry I'm running out of time. I hope I've convinced you that you have to pay attention to construction lien issues when advancing under a mortgage. Thank you.
The second speaker to talk about environmental contamination is Donna Shier. Donna and I met yesterday, frankly, for the first time when she made a presentation to our firm, and I ranted and raved at her, frankly, because she's even agreeing, because I said the problem with environmental lawyers is that they all think that environmental law is the most important aspect of any real estate deal. But she will say that's not, is it true or it's not true? It's not true. That's what I said the problem with. Remember, I speak in generalities. In any event, and I said you go talk to a corporate lawyer, the most important thing is the corporate status of the firm and of the deal. And really what I was trying to get across was that we real estate lawyers have to deal with a whole lot of things and try and put them all into context. Well, I was pleasantly surprised to discover that Donna is not only an expert in environmental law, but she's also very practical, and she sees the big context, the big picture of the deal, and isn't one of those environmental lawyers who, when they get together and they say arsenic, they both laugh. You know, she's very practical, and she's going to tell us what you do with contaminated land.
Using my time.
You got 21 and a half minutes.
I'm from New York. I talk really fast. So my topic is challenges in developing contaminated land. And to quote Stephen, this is an exciting area. My paper talks about cleanup and about changes in the law to the cleanup standards, and about some things you want in your agreements, and about brownfields legislation, and I'm not going to talk about any of that. What I'm going to do is describe two different brownfields deals at the agreement of purchase and sale stage. Both deals were for the purchase of contaminated land for redevelopment. Both redevelopments are proposed for property that will be the subject of risk assessments. Now, I'm going to say site-specific risk assessments sometime, and I'm going to say SSRA, and I'm going to say risk assessments. All that is under the current law, we call them site-specific risk assessments. Under the new brownfields, we will call them risk assessments. So they're the same. On both properties, contamination levels exceeding the guideline, that's this, the guideline for use published by the MOE will remain on site. They will have appropriate engineering controls, and the use of the properties will have MOE and municipal approvals. Both deals are now. They were signed at the end of 2003. Purchaser is the same in both transactions, and the deals are totally different. I like one a lot, and I don't like the other one very much at all. What I'm going to describe to you is my part in your deals, the environmental part of both deals, not the commercial part, not the real estate part, not the conveyancing part. There are three important things to remember when developing a contaminated site. Three additional complexities on top of all your regular complexities. The first is, how is purchaser going to finance? The second is the technical. The types of contamination, the extent of the contamination, the cleanup standards, the engineering controls, off-site impacts, and those kinds of things. And the third is liability. Civil, statutory, and our regulatory regime is in a state of flux now with the new brownfields law. So deal one. This is the deal that I like a lot. Here are the environmental facts. Vendor prepared a site-specific health and ecological report that identified the environmental risks and requirements for obtaining a site-specific risk assessment, SSRA. And that's for the purpose of developing this land without cleaning it up. But this is the deal I like. Vendor shared the report with the purchaser prior to signing the agreement. The agreement obliged vendor to deliver to purchaser a record of site condition, that's important, that was acknowledged by the MOE and addressed to vendor and purchaser, that's important. Under the new brownfields law, the MOE must accept the RSC so it can be registered on the environmental site registry, that's important. The agreement of purchase and sale provided that the RSC had to be acceptable to purchaser and to purchaser's environmental consultants in purchaser's discretion. The agreement to purchase provided that the RSC would be suitable for purchaser's proposed land use in accordance with a site plan. Makes it very clear what purchaser intends to do. Vendor covenanted to provide the record of site condition that would permit purchaser to construct purchaser's development in accordance with the site plan. Vendor was obliged to produce to purchaser vendor's environmental engineer's draft SSRA report, all of the peer review documents, all of everybody's comments. So purchaser knew everything about this property. So this is why I like this deal. Vendor does all the engineering work, the field work, the report preparation, and purchaser gets to review it all, so purchaser has full disclosure. Purchaser knows the precise form of the development it can build on site. Location of the restaurant, location of the bank, location of the slab-on-grade commercial, and the location of the 210 parking spots along with access and egress. Vendor handles the public consultation required as part of the development of contaminated land SSRA process. Purchaser knows it's going to get a record of site condition. That's important for liability in the future. Purchaser knows engineer will be able to sign that record of site condition, and that's important because of the new law and the changes in liability. Purchaser knows that vendor's engineer, who is preparing the SSRA, is what we affectionately call a QP2, a person qualified to sign a record of site condition arising from a risk assessment, that is a record of site condition that will permit the development of contaminated land. A regular QP or QP1 signs a record of site condition for land that meets the guideline. Purchaser knows that the RSC will be registered on the site registry. That's important, again, to reduce liability into the future. And the record of site condition will be acknowledged by the ministry. Again, a liability issue. So the purchaser can factor into its purchase price the assessment of the stigma attached to, that is the diminution in value attached to owning contaminated land. Also can factor in the cost of the engineering controls that will be ongoing as a result of developing contaminated land, and can calculate its prospective rental revenue in order to calculate its return. I like the deal because vendor and purchaser paid careful attention to my details in addition to all of your details. The details essential to successfully completing the risk assessment process. And they cooperated so that vendor and purchaser both will have the protections under the new brownfields laws. Deal 2. The one thing I can say about this deal is purchaser really wants this property. At the time the agreement was drafted, vendor and purchaser each had their engineering consultants, but none of these experts understood the full extent of the contamination. No one had finished the field work. From what we did know, the source of the contamination was still on site and was migrating in two directions, off site and more on site. So that covers about everything. Vendor insisted on closing by the end of 2003. Vendor insisted on maintaining complete control of whatever engineering investigation was going to be done. Vendor insisted, I should have done vendor insisted : list, but vendor insisted on maintaining complete control of the cleanup and complete control of the extent to which the property was cleaned up. Vendor proposed a remediation plan that would be part of the agreement, a schedule to the agreement of purchase and sale, but wouldn't commit to a remediation standard, which I would have thought would have been fundamental to a remediation plan. Not to cleaning up to the guideline, and not to cleaning up to a risk assessment standard that would go through the risk assessment process, like Deal 1, that would yield a record of site condition that could be registered on the environmental site registry and give those protections from liability. Vendor refused to deal with the dirty groundwater and said that whatever it would do, which we didn't know, it would only do for soil. And just to add a little space to the deal, the engineers didn't agree on the data that was, the limited data that was available. Purchasers' engineers felt that the site could be cleaned up at a very reasonable cost, which meant, of course, that we wouldn't have to go through the whole risk assessment procedures and so on and so forth. I proposed a cleanup by the vendor with a cost cap, and the balance of the cleanup cost to be paid by purchaser, because it's a real benefit to purchaser to have a clean property rather than a risk-assessed property. Failing that, I proposed something similar to Deal 1, a risk assessment, but with a site plan, so purchaser knew what it could use the property for. Vendor wasn't interested in cleanup, not to the guideline and not to risk assessment, and vendor wouldn't accept a site plan. Vendor, while negotiating with purchaser, was also negotiating with the MOE about the installation of a barrier wall. And the barrier wall was to keep contaminated groundwater, was to clean up contaminated groundwater that was going off-site. So you see the kind of complexities of this. Purchaser didn't want a barrier. It wanted the site cleaned up. It wanted the source removed. Purchaser even went so far as to ask vendor to apply the cost of the barrier against the cost of removal, thinking that purchaser could just top it up and we would move forward with a clean site. Anyway, I didn't want a barrier. I didn't want purchaser to assume the headache of the ongoing maintenance of monitoring of the barrier, because with environmental law, you don't just install it. You monitor it forever to make sure it's working. I wanted the source removed. I wanted to see whether, once the source was removed, the rest of the property could be cleaned at some reasonable cost so as to avoid risk assessment. I wanted to see a full engineering workup so we knew what we had. And then I wanted vendor and purchaser to really sit down and talk about what the deal was going to look like. One of the big problems with this deal was that the vendor was an American vendor and had never done an SSRA. So it didn't get the procedures. Another big problem was that vendor's engineer wasn't from Ontario. So in addition to the fact that they had also not done an SSRA, I was concerned that I wouldn't be able to qualify them as a QP2. And you remember from Deal 1 that that's important. So you may ask what vendor proposed to give purchaser in exchange for purchaser's payment of its millions of dollars. A barrier wall, a remediation plan, but not one that would yield a site that met the guideline, not one that would yield, under the procedural requirements, an SSRA, and no record of site conditions signed by anybody, let alone a QP2, which is what purchaser needs to take this forward for development. Vendor was prepared to say that the soil that didn't meet the guideline would be excavated and treated on site, that's like bioremediation or something, or risk assessed. So what kind of certainty? Is it going to be a clean site or a dirty site? And nothing about groundwater. What I couldn't get vendor to understand was that if you have clean soil and dirty groundwater, you still have a dirty property. The very worst part of the deal was that vendors' obligations, however unclear they were all going to be completed after closing. The deal was structured such that purchaser paid its millions within several weeks of signing, and vendor was going to finance the cleanup, or whatever it was, from purchaser's payment. And vendor had a couple more protections that were amazing. If vendor didn't complete the remediation plan, which you remember I didn't like because I didn't know what it said, at vendor's own discretion, purchaser could refuse to keep the property and ask for a partial refund. So purchaser could keep the property but ask for a partial refund if vendor didn't complete the remediation plan. Purchaser could, if vendor elected not to complete the remediation plan, purchaser could give the property back and vendor would refund the money. Problem. Vendor is a numbered company with no assets but this dirty property. Vendor didn't provide any security. Nothing to secure the performance of any of its obligations, not the ones we understood and the ones we didn't understand, let alone the refund or partial refund. Finally, we can't overlook that even if purchaser gave back this dirty property to vendor, that still leaves purchaser as a former owner of this dirty property. And under the Environmental Protection Act, prior owners, officers, and directors of prior owners can be liable. And they can be liable for orders and for prosecution. So I proposed what I thought was a dynamite amendment to the Agreement of Purchase and Sale, and I drafted a remediation plan. And in it, I put a cleanup standard. Vendor was to clean up to the guideline, or to do an SSRA. How am I doing? Okay.
10 minutes.
Oh, phew. Can I slow down? So, what I wanted was a cleanup. Because remember, my engineers told me that for a couple $100,000, all the problem would be gone. And we're talking of millions in the purchase price. So I wanted a cleanup to the guideline, not to pristine, don't get me started on Rosalind, try to. I wanted a cleanup to the guideline. And I wanted a cleanup of soil and groundwater. I wanted vendor's engineers to do all the work and address all the reports to vendor and purchaser, because I'm thinking about the brownfields amendments, and I'm thinking that the owner has to file the RSC on the site registry. And remember, purchaser's going to have paid its money, because the deal has to close within minutes. The RSC was to be signed by vendor's engineer, and vendor's engineer had to be a QP2. Somebody who could sign the most complicated RSC, just in case I had to go a risk assessment. Vendor was obliged to obtain the RSC, and to do that had to have approval of the MOE and the municipality. so that the RSC could be filed on the site registry. Purchasers' engineers were to have complete access to the site so they could do verification testing and were to receive all of vendors' engineers' data. I included an indemnity, which the conveyancing lawyer drafted, because all I had to say in my niche is I need an indemnity from vendor to purchaser, and it has to cover existing off-site contamination. Off-site contamination, because so far I've just talked about the property. And I want the indemnity secured. Back to the conveyancing lawyer. I included an indemnity from vendor and purchaser for re-entry of contaminants back onto the premises. Because remember, contamination goes this way and it goes this way, depending on groundwater flow and so on and so forth. So I wanted protection in case the contaminants re-entered the site. I included a provision that vendor had to complete a risk assessment if Table B couldn't be achieved. I specified that any control measures or risk management measures included in the SSRA had to permit the development of the entire site. Remember my site plan. The entire site for commercial industrial, that's what purchaser wanted to do, without impediment to form and location of the buildings and appurtenances. You don't have to write this down, I can give it to you later. Without impediment to form and location of the buildings and appurtenances in accordance with the current zoning and with the approval of the municipality and the MOE. Because purchaser doesn't buy land like this at this price to be able to not know where it can put its buildings and how much density and how much rental revenue and so on. I required that the risk assessment yield the RSC that could be registered on the site registry. That way I got municipal and ministry approval. I thought about requiring vendor to pay the cost of ongoing engineering control measures and monitoring, and I hope that that would induce vendor to clean up rather than risk assess. But I couldn't get anybody to even let me write that down. I explained more times than I thought possible that when people say, we'll just risk it away, they don't mean that. Contamination does not get risked away, not by risk assessment or anything else. The contamination is still there. It requires management and control. It requires monitoring. It requires a contingency plan. It limits the uses to which the property can be put. It adversely affects the property's value, and it adversely affects the owner's ability to finance it, which is why I wanted it clean. Anyway, I thought I did write a great remediation plan. My mother said, speak with authority, but nobody bought it. So this is what's happened so far. Purchaser completed the purchase on the goofy terms I outlined without any protections. The millions are paid, the barrier wall's going in. I don't know, who knows about the level of cleanup. All I want you to remember is, this property must be pretty good to purchaser, and not all properties are that good. In fact, I think this one's not going to look so good as things unfold. So we'll see, but I can't but imagine that we're going to be back at the table on this one. Finally, back to my three things. Financing. Purchaser self-financed both deals. Technical information. Here, the technical information was absolutely nailed in the first deal, which is one of the reasons it went so smoothly. And it wasn't fully investigated in the second deal, which is one of the reasons the deal was so difficult. And finally, liability and process protections. In the first deal, purchaser knew precisely what it was getting. It knew exactly, and we could talk about liability issues. We could talk about protections from the new law and so on. And the second, it's just a big question mark, and as far as I'm concerned, the risks are absolutely unquantified. So that's it.
Donna is going to be back at the question period, at which time she is going to explain the following to us: SSRA, RSC, and the site registry. she is also going to explain to us about liability. And that is the common question that we often have, or when the client comes in and says, what's my liability when I discover my property is contaminated? So I'm giving her a heads up so that she will know that that's a question I'm going to ask because I want to know. We have a 15-minute break, and then we're back again.